Jai Hind, dear fellow children of India. Wishing you a very happy Independence Day. This day is indeed always a day of pride and determination for all citizens, especially those like you who have taken up the mission to contribute in the bigger dream of nation building and public service. It is essential for me and for you, all of us, to not forget the solemn goal civil services have, what Sardar Patel would have expected from all of us, or Gandhiji would have liked us to understand from all the words of wisdom he could ever share with us. That is, to keep public service at the core of all our decisions and actions. When we are talking of being Atmanirbhar Bharat, we must ask ourselves, are we Atmanirbhar? Are you Atmanirbhar? Am I Atmanirbhar? Not just with respect to material needs, that indeed is important, but even spiritual and other needs. I see so many of us habitual to seek validation of our own strategies, say even for this exam. So much lack of confidence. Even after a year or sometimes even more time of preparation, people still feel lost. The youth of my nation cannot be lost, as this is the youth which has to shape this nation. And I, for one, is fully sold to the idea that it is you who will do magic. Because if you don't, then nobody else will. So do the right thing, always. And with that gyan, let us take 10 more questions to learn more about our country's system of governance and other related issues. You know the usual drill. Keep your copy of the Constitution for quick reference. As soon as the question is displayed on the screen, pause the video, mark your answer, and only then proceed to listen to my explanation and guidance points. And for this video, you will see on the right hand side the name of our country written in different languages. Your task is to identify the script as to which is the language used. Lastly, do watch the video till the end for extra learning and the extra lessons. Even if you wish to skip or fast forward, do that, but go till the end. Alright, so let's take the first question here, which is the country recognized as the first to enact a legislation for providing the right to information. Of course, we know by now the answer is Sweden. All this happened in 1766 by the Freedom of Press Act. This was all largely influenced, the people who were behind all these things. They were influenced by the good practices of the Tang the dynasty of China, right? Around the 7th century AD. That was the time a lot of things were happening, and they were motivated by that, and that's when the first Rti Act, actually it was called Freedom of Press Act, enacted in 1766. See, 1766, this is what I get amused, that, civilization is a journey. In 1766, people of Sweden, reformers of Sweden, were talking about right to information, that it is the right of the people to know, it's the right of the representatives of the people to know, it's people's information, not the king's information. We, even in 2020, are struggling to save our RTI activists. Most of the citizens, I don't know about you, you are also a citizen, you can judge yourself, don't even know what RTI is, don't even know what RTI does. I have to struggle so much to make people understand that what this powerful tool is. So it's really amazing how the whole world is at different levels of, maturity of civilizational thoughts. Anyway, so this was largely motivated, the 1766 Act, by the Parliament's interest in access to the information held by the king, as I told you. Then Finland became the second country, and you know when? That was many years later in 1951. See the gap between, even these countries which we think are developed countries. And then USA was the third country, where, after the Watergate scandal, etc. of the 50s, in 1966 they made the act, and of course another Scandinavian, Norway, in 1970, and with that gradually, we also got our RTI Act in 2005. More than half of you got it right, so that's okay. It's factual information anyhow. Next question is, the Lokpal and the Lokayukta in India are inspired from the Ombudsman of other countries. The institution of Ombudsman was first developed in Sweden. This is also coming from Sweden. However, you should know that the Lokpal that we have, if you agree that we have Lokpal, that is itself debatable. It is not truly the counterpart of the Swedish Ombudsman. It is much wider. This ombudsman here, which they have, is much, much wider. It is beyond even corruption and things like that. The Parliamentary Ombudsman, which is appointed by the Swedish Riksdag, and that is the Parliament of Sweden, to ensure that public authorities and their staff comply with the laws and other statutes governing their actions, right? It is actually entirely good governance based thing. You can just go to the website if you someday have some time. People who have public administration as optional definitely should know a lot about them. That on the right hand side, by the way, is written in Telugu, and actually it reads Bharat Desham. See, I know that especially from people who are from northern India or eastern or northeastern India, they are not able to differentiate between the languages, especially in the south, because there are so many and they all have overlapping characteristics. But still, if you look closely, you will find the differences. That's the task I think you all should have, unless you are a native speaker. Then of course you'll realize that. So the next question we have is, recently Mitakshara has been in the news. I'm sure you have noticed this a lot. This is actually a concept which is more important for you in ancient history, right? From art and culture perspective, please focus on that. Which of the following statements are correct about Mitakshara? It lays foundation of Hindu law on inheritance of property, Hindu Succession Act. Absolutely correct. This is what was in the news just a few days back. I think the same day I put up this question also, when Supreme Court has now held that daughters are also daughters for life. They also have the right like a son. We'll come to that in the last two options. It was written by Vigyaneshwara. Yes, absolutely correct. There's some confusion. I find people say that it was written by Yajnavalkya. It was not by Yajnavalkya. Actually, Yajnavalkya Smriti is another document, and Vigyaneshwar wrote a legal commentary on the Yajnavalkya Smriti, and that commentary is what is Mitakshara. So this is where ancient history also comes in the picture. You should know all these facts. Then it is based on the notion of birthright of the son. Birthright of the son over the properties of joint family. Absolutely correct. This is the fundamental thing you should know. It is birthright. That means the moment the son is born, they have a right. There is another school of thought which is not Mitakshara. It is called Dayabhag, which is prevalent in some parts of India like West Bengal. In Dayabhag, it is not the birthright. It is on the death of the patriarch. Right? Till that time, there is nothing that you can claim. Here, by the fact that you are born, there is a claim. Right? In the ancestral property also. It's not just the parent or the father's property. It's the ancestral property also. So there are rules as to how many sons should be there at minimum and maximum and things like that. Now, this is how Mitakshara is. And that's where comes the important fourth point. It provides equal rights to the daughters in the joint family. No, it does not. It is with the amendments to the Hindu Succession Act as well as Supreme Court's judgment, like the recent judgment, daughters are now as good as sons. But the Mitakshara principles are not based on that equality. So this is something which is there today. I told you 2005 amendment. So in 2005 amendment, the act said that daughters are same as they are same as sons, right? They are all equal in the rights of the inheritance of property. But the condition was that because it is an amendment of 2005, the father must have been alive in 2005. So anybody who died before that, then those rights cannot be claimed. Now, recently, just a few days back, what has Supreme Court said? I'm sure you read that it doesn't matter. If the son has the right, daughter also has the right. Right? It doesn't matter the father was alive or not alive in 2005 amendment. It is since birth. Again, it's a birthright. I hope you got some of these things. I'm not teaching you Mitakshara or anything. It's not needed to go in so much detail, but because this is landmark things, you should have some vague ideas. And not that vague also, but at least broad ideas. Sorry, not vague, broad ideas. And this, by the way, is in Urdu and it reads Hindustan. Kindly forgive me if some of the alphabets are not accurate or my pronunciation is not right, because I'm not a native speaker or writer or reader of these languages. Even I have learnt for making this video. So I think you can forgive me, and if there's any mistake, you can update yourself and update me also. I would love to learn that, because I don't claim to know all these things that I'm writing on the sides. Okay, let's go to the next question, and that is a grant where the funds to meet the proposed expenditure on a new service is to be made available by reappropriation. Reappropriation means from head 1, the money is simply shifted to head 2. So overall, the impact is nil. So there is no additional expenditure that is happening as such, right? So it's just the head of account is being changed. So let's see the options. Balancing grant. Actually, there is nothing called balancing grant. It is just rubbish option I've created for you. So ignore that. It is not an option. Then you have additional grant. I'm sure you know additional grant is for an additional service. So yeah, that is also a new service. But it is not foreseen in the budget. So if it is not foreseen, you don't know how much money you need, etc. So it is for a new project altogether. So, it's not for reappropriation, etc. It is a totally new project where, it is not even known or envisaged in the budget of that year. So then you have exceptional grant. Now this is where I find people generally get confused as to what exactly is exceptional grant. See, first thing you should know, it has never been presented to Parliament so far. Exceptional grant has never been presented to Parliament so far. Now this is a special purpose grant, okay, special purpose grant for some work which is not part of the ordinary expenditure of the financial year. It is perhaps, it's my guess because it has never been done, so it is perhaps to take care of any expenditure which is not related to government's regular work. Because whatever the government spends on is covered through ordinary expenditure, right? So it is for those kind of situations. I hope if you read carefully and listen to what I just said, you'll get the difference there. Okay, and this is Kannada and it says Bharata. So let's go to the next question, and that is, according to the Constitution of India, during which of the following situations can the legislature of a state make a law with regard to trade and commerce making discrimination between one state and the other? This is from Article 303 of the Constitution, and if you see clause 1, if you have not read 303, please pause the video right now, read now. You will never learn otherwise, you will just know answers to questions. If you want to improve, read quickly. So it says, in fact, it prohibits the state and the union legislature both of them, to make any law that gives preference to one state over another or discriminates between the states. So it says nothing like that is allowed. However, it goes further in clause 2, and then it empowers the union legislature, not the state legislature, only the union legislature and the Parliament of India to legislate, to give any preference or to discriminate among the states, provided it is for the purpose of dealing with a situation of scarcity of the goods in some part of the country. There is no other ground for which Parliament can make a law. However, the question is about legislature of the state. So even this is not there for legislature of a state. On no ground at all, the state legislature can discriminate. Yes, one ground, that is the scarcity, is provided for the Union Parliament. And that is for obvious reasons as to why it has not been given to the states and only to the Union. I hope you can guess. And that is ODIA on the right hand side. See, again, this is what I say, not even 1/3 of you are getting it right, even though this is nothing but straightforward ideas from the two clauses. Now, if you don't read these things, trust me, no cosmic or extraordinary energy of the universe can get these things right. No new book, etc. You just need to read your textbook and wherever referred, the bare act of the Constitution or simply the Constitution. Okay, so ODI it reads, Bharat, let's move on to the next question. The criminalization of sexual acts of same-sex adults in private under section 377 of the Indian Penal Code has been declared by the Supreme Court as violative of which constitutional provisions? A very, very important question. Actually, all the four are correct. In fact, these four and only these four are what the Supreme Court held this as violative. Now, first thing, see, even I have been very particular about the way I framed this question. I did not say that section 377 has been declared void. It says certain part of this interpretation, that is the criminalization of sexual acts of same-sex adults. 377 does not talk about just that, but 377 is used for those kind of activities of the people. So understand that section 377 is still a valid provision of the IPC. What has happened is that its interpretation has been read down. Insofar as it criminalizes consensual sexual acts between adults in private, court said it is not based on any sound or rational principle, since the basis of criminalization is sexual orientation of a person, over which one has little or no choice. Now, this is what the court said, that person has no or little choice. Though the rights activists tend to agree that there is no choice. Anyway, that's not for us to debate here. Further, the phrase carnal intercourse against the order of nature, which is written in section 377, as a determining principle in a penal provision like this, where you give penalty, is too open-ended, giving way to the scope for misuse against specifically the members of the LGBT community. Also, it does not satisfy the twin test of Article 14. I'm sure you know that, if any law is to be made to discriminate, Article 14 has twin test. If those twin tests are not satisfied, then that discrimination is invalid. Otherwise, some discrimination could be allowed. So it's the twin tests, I'm sure you know. One, that there should be a reasonable reasonable classification based on some intelligible differentia. So reasonable classification should be there. And secondly, it says that the classification should have a rational, direct relationship with the objectives that we want to achieve. So you should have classification, and then classification should be required for achieving whatever objectives that particular legislation wants to achieve. So section 377 court says is arbitrary, and hence it is violative of article 14. Then the court went further and said that the prohibition that is there in article 15, so article 15 prohibits that we cannot discriminate on the ground of race, religion, caste, sex, place of birth. So sex is a word there. So the court said that that word sex, it encompasses instances where discrimination takes place on the basis of one's sexual orientation also. So that is definitely a violation of article 15. Hence, section 377 prevents LGBT persons from leading a dignified life, as is guaranteed under article 21. It also violates right to privacy, right to health, all of which are integral to the dignified life. See, article 21 is always blanket. If any fundamental right is violated, article 21 definitely is getting violated. Then the interesting part is this one, that LGBT persons express their sexual orientation in different ways. Expression of sexual orientation. One such way is engagement in intimate sexual acts like those prescribed under section 377. So freedom of speech and expression is also getting violated. Now somebody can ask, and this was very well discussed in the court also, that freedom of speech and expression is not an absolute right. It can be restricted. How? Provisions are provided in clause 2 of article 19, and one of the grounds says public and social morality, right? So morality is one of the grounds. Now the court held that section 377 cannot be justified as a reasonable ground here in 19 clause 2 on the basis of public or social morality, because these terms is inherently subjective and there is no clear nexus here. So hence 14, 15, 19, 21, all of them are violated here, and that is a Bharat in Punjabi. I hope my accent was okay. So let's move on to the next question. Which of the following statements is or are correct regarding impeachment of the president? In the American presidential system, the motion of impeachment passed by the House of People leads to the automatic removal of the president. No, absolutely wrong. You have seen that recently. House of People only passes the articles of impeachment, which is what he said, the impeachment motion is passed. But then the motion will then go to before the Senate, and the Senate will undertake the trial, right? And then the removal of the president takes place. So actually impeachment and removal are kind of, still you can understand in the American lexicon, it is two different things. So understand the process, and that is okay. In India, the passing of the resolution for impeachment does not necessarily lead to the removal of the president. Absolutely wrong. It is necessary. We know the moment the second house has passed, and that is meant by passing the resolution, the second house has passed the resolution, at that very moment president has been removed from the office, president is out of the office, right? So both of them are actually wrong. And that, by the way, a lengthy sentence or phrase is Malayalam, and what it reads, Bharat Maharajyam, which is actually, I tried to put here Republic of India, something like that. Okay, so let's move on to the next question. Which of the following statements are correct regarding the recently reconstituted cabinet committees? I'm sure you know there are 8 standing cabinet committees right now. It says the Prime Minister is not a member of some of these committees. Absolutely correct. In fact, out of the 8, only 6 of the committees, Prime Minister is a member. Prime Minister is the chair, he is the head. But there are 2 committees, one on accommodation and the other on the parliamentary affairs, where it is not the Prime Minister who is heading or is even a member. Then Cabinet Committee on Investment and Growth and Cabinet Committee on Economic Affairs are headed by the Prime Minister. Absolutely correct. The point is, don't get confused ever, because they may look like as if it is the Finance Minister who should be the head. No, I told you, except these 2, all 6. The Prime Minister is the member, and of course he is the member, so he is the chair also. Then the Cabinet Committee on Parliamentary Affairs is often referred to as Super Cabinet. No, it is the Cabinet Committee on Political Affairs, right? Political affairs, not parliamentary affairs. So the question is why? Why political affairs is called super cabinet? I will actually leave it for you to ponder. See the membership to begin with, and also the mandate of this committee, political affairs committee. You'll get the idea. In fact, the mandate of this committee, the Political Affairs Committee, is the shortest written mandate. It is just 3 points. 3 lines are there. Everything else is even in pages. But the impact of this committee is perhaps the maximum in governance, especially the direct impact. That's in Gujarati. It says Bharat. You can read that and see the performance here. Again, this is a question I have told you even in the classes, those of you who have been my students. Otherwise, also I keep saying, this is governance. This is the real decision-making part. And if this is not clear to you, it tells me one thing. Either you are not really getting the hang of the exam, or you're also not very much interested in governance. You're here for this exam, but you actually are not the one who has a natural interest to understand how government works. And that's where we will come to the next question also, which is another thing which I did not really like the kind of performance people had, 1/4. And I'm simply asking, what is the structure of the government of India? How does a ministry function? So let's see here today. So at the top, obviously, you have the ministry, and each ministry may have a lot of departments, and the department will have a wing, and the wing will then have certain divisions, and then division will have some sections, and like that. But these are the most important things. This is where somewhere your career begins, in between the last two here in this chart. So minister, of course, is headed by a minister. A department is headed by a secretary. A wing, you will have an additional secretary, or sometimes even a joint secretary could be there. Additional is obviously higher in rank than joint. Then the division, you'll have a director, or what is called a DS, deputy secretary. And then a section will have a section officer. So in between that, you also have under secretaries, which is your first promotion after you join, after clearing this civil services exam, and if you get group A service, of course. So anyway, this is just to make sure you understand how the government is also designed, how this whole structure works, how the machinery moves. All right, and that's Tamil, by the way, and it reads Bharatak Kudiyarasu. Again, Republic of India, Bharat Ganarajya. Okay, so the last question for this video, the nodal ministry under which Central Information Commission functions is MOPPGP, the Personnel, Public Grievances and Pension. See, these are not questions I put in there so that it's a test of memory or something. They look very factual, but these are things where we need to perform better than just half of us. See, CIC is about giving information from the government. Who gives information? Again, the personnel. Also, it's about administrative reforms, right? Department of Administrative Reforms and Public Grievances comes under PPGP, this DARPG. So all these kind of reforms and improvements and things like that, they naturally come under the Personnel, Public Grievance and Pension Ministry. So this is how we are supposed to be. We have to understand and we have to learn how this entire humongous system of the government functions. And that there, friends, I hope you recognize, is Bangla or Bengali, and it says Bharatiya Prajatantro. I hope you can give me some marks for my pronunciation there. So to end this video, like always, I've got some short learning for you. I thought I'll today tell you briefly about the Ashtang Marg, the Ashtanga Yoga, the eightfold path as was given by Patanjali in the book Yoga Sutra. This is the eightfold path leading all the way to Samadhi. The true destination of yoga is Samadhi. That is the yoga. Yoga means addition, right? Summation. The unity of Atma and Brahma. That is the Param Atma. So the integration of that, the unity of that, and that's why the name also of this entire concept is yoga. Yoga means summation. So soul meeting the supreme soul, that kind of an idea. But it goes through 7 stages, right? So spend, by reading 2 or a few lines, spend some time about each of these stages to evolve your true understanding of what is the treasure that yoga truly is, and not just the marketed version which largely is visible but is focusing on just 2 aspects of asana and pranayama today. For example, see the first step. The first step, yam, and before we go to niyam, it talks about the 5 points of external conduct. Ahimsa, that is non-violence, or that is, in a positive sense, you can say kindness. Then you have satya, that is truthfulness. Asteya, that is non-stealing. Don't go after things which don't belong to you unless you put the effort to earn, don't take shortcuts, basically. Brahmacharya, right use of energy, or sometimes also used to give the idea of moderation, that do everything but in moderation. Don't indulge into certain things. Don't just sit down and keep, Netflixing all the time, that is. And the fifth one, aparigraha, which is non-attachment, or generosity. Don't get attached to anything, and anything means anything. So generosity, being kind and forgiving, and going outward. So those kind of external disciplines. And then comes niyam, which is the discipline of your own self-conduct, thought and body both. So anyway, spend some time to read, and I'm sure if you read and implement even small parts of it, you'll develop a personality of envy for other people. You'll develop the personality I think all citizens of India should have, and this is all our sacred learning. Somehow we have lost, and we are only focusing on certain parts. Why? Because the world is focusing on that part. Anyhow, with that note, I'll leave you with all these ideas and thoughts. I'll see you soon with 10 more questions. Till then, study well.